very simple bill. We're effectively telling the Attorney General that no longer, as the current statute requires, must he be compelled to oppose one of these transactions. And the bill simply takes away that compulsion and makes it a may rather than a shall. And I understand that on its face, and it does not seem like bad policy to me, just looking at it right here as a layman. But what I'm wondering is where this comes from. What brought this issue to us? What is the purpose for making this change? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. This was brought to us by one of my colleagues, Senator Austin, as well as by one of our federally recognized tribes, the Mashantucket Pequot tribal nation, and I believe it is, and it has not been opposed by anyone. And I do think that it is important that this legislation originally was, the statute was originally written in the 1990s. I believe that it was never intended so that the AG would be required to oppose every application for a change in the status of the land. And clearly, it's something that we should embrace. I believe that if there were to be a problem with an application, the AG would act on that if there was some concern, but it should not be required of the Attorney General in every case to challenge such application. So I believe this is making it not only would serve the state well to save our resources when there are so many other cases before us. We don't want to have any kind of unnecessary litigation, but it also, I think, is important in recognizing the great partnerships that we've had with our tribal nations here in the state, and that they also would not apply for this change in status without good reason. And so I encourage all of my colleagues to support this bill, and I hope that suffices to the good senator's question to understand why this is an important bill to pass today. Thank you, Madam President, through you.
Thank you very much. I'm sorry, Madam President. Thank you very much for that answer. And I appreciate the clarification and the understanding of what the impetus behind this proposed legislation is. I'm just curious if the good chairman knows how the original statute came to be. Through you.
Senator Kushner.
Thank you, Madam President. While I was not a member of the legislature, I don't even believe I lived in the state. In 1992, I believe it was passed. And at that time, I think that the intent of the statute was, since it is paired in a section of a bill that has certain statutory requirements or encouragement to have labor rights codes, that in fact that it might have been intended at one time to interact with the adoption of labor rights codes by a tribe. However, it is not clearly stated in that way. In fact, it is a separate paragraph that compels the Attorney General on any application for a change in the status of a land parcel. And so I don't think it ever was utilized in that regard. I will make note of the record that I do know this Mashantucket Pequot tribe very well, having worked with them when they established their tribal labor laws, and in fact their employment code that is in their tribal laws is a very good tribal law. I embraced it as well as the members of my union embraced it, and we have worked very well with the Mashantucket Pequot tribe through the labor issues. So I don't think there's any reason to connect those dots any longer. It's well past any time when there might have been a question, and certainly we have seen good labor relations in the Mashantucket Pequot tribal nation with their unions, and they have many unions. But I do want to make note that that was quite some time ago, and I think that it was probably an error in the drafting, and so clearly we aren't in a position today where we want the AG to oppose every application without any cause. Thank you, Madam President, through you.
Senator Sampson.
Thank you very much, Madam President. I don't propose to be an expert on this topic, and in fact, I'm just now discovering a lot more background on what's happening here than I was aware of during the committee process. In the committee, we voted this unanimously out based on the understanding that we simply just didn't want the AG to be compelled to oppose every one of these transfers, and instead would give him the latitude to do so. But today I'm realizing that there was a statute passed back in 1993, and the legislature voted, in fact, this body, the Connecticut State Senate at the time, there are, I don't know how many members are still persistent, but there were members at the time. This passed 31-5 at the time to require this mandatory, compulsory opposition by the Attorney General. And I'll just make a note that the statute actually reads as follows, just one tiny section. It says the bill requires the state to oppose the tribe's application to the U.S. Secretary of the Interior to convert parcels of land the tribe owns into part of its reservation. And this part is interesting and specifies that such conversions are contrary to the state's interests. I'm curious if the gentlelady understands why they would have had that opinion in 1993 and what has changed since. Through you, Madam President.
Thank you, Madam President. As I stated, I believe that there was some discussion at the time about whether or not the tribal nations would adopt appropriate tribal labor laws, and I believe that was the context. And what I can confirm is that certainly at this time, I would say that the Mashantucket Pequot Tribal Nation has a very robust tribal labor law, one that is put to test frequently through their labor relations, through collective bargaining agreements, binding arbitrations that have occurred. And so I believe there is no reason to think that we still need to compel the Attorney General on every application for a change in status for the parcel of land. Through you, Madam President.
Senator Sampson?
Thank you very much, Madam President. Am I right that what this practice that we're referring to is really to convert a parcel of land owned by the state of Connecticut into federal trust status, thereby making it eligible for the tribe to purchase it and make it part of the reservation? Am I correct about that, through you?
Senator Kushner.
Please stand at ease for a moment.
The chambers will stand at ease. Kushner.
Thank you, Madam President. I just wanted to confirm what I thought, which is this land is already owned by the tribe, by the land that we are talking about is already owned by the tribe, and it's changing it from land that is called fee interest land to land in trust.
Senator Sampson.
Thank you very much, Madam President. I appreciate that response, but this doesn't just have to do with land that is currently owned by the tribe. It has to do with any land that they may purchase in the future also. And the objection back in 1993, I think, is becoming much more clear now, which is that the idea is that if the tribe purchases land or has purchased land and they own it, but it is not necessarily part of the reservation, this particular process that is being referred to in the bill would allow the tribe to turn that into land that is merely possessed by them, that is taxed like any other property in the state of Connecticut, and that can be transferred back and forth between other residents and so forth. And it would, in fact, change it into federal reservation land, and therefore would be forever part of the tribe's reservation and no longer subject to the same encumbrances that a regular piece of property would. And that is why the opinion back in 1993 was overwhelming that this was against the state's interests to be transferring land that is possessed by the state of Connecticut and its residents into reservation land. And that is why they required the Attorney General to oppose each one of these cases based on that assumption, which is right in the statute that we're talking about, which says the conversion shall be deemed contrary to the interests of the state and its residents. So not only is the bill before us changing the shall to a may, but it's also taking out that sentence. But I don't think that sentence is untrue. I think it's just as true as it was back in 1993. And as a result of that, Madam President, I'm going to oppose this bill because I do now understand why our colleagues in the past voted overwhelmingly to put this law into place, and that it is improper for us to be overruling them today, a mere couple of decades later. Thank you very much, Madam President.
Will you remark further? Will you remark further? If not, will the clerk please announce a roll call vote? The machine will be open.
An immediate roll call has been ordered in the Senate. An immediate roll call has been ordered in the Senate. We're voting on Senate Bill 1027.
Voted. If all members have voted, the machine will be locked. Would the clerk please announce the tally?
Total number voting 36. Those voting yea 34. Those voting nay 2. Those absent 0.
The bill passes. Mr.